Good afternoon. And welcome everyone here at Albany Law School and on Zoom. For those of you who don't know me, I'm Leslie Stein, the director of the Government Law Center here at Albany Law School, and the home now of the Fair Trial Free Press Conference. We are very pleased to support the conference and to be able to present to you programs such as we have today, where we have discussions between judges, lawyers, and journalists regarding the interplay of the related legal, constitutional, and ethical considerations of various scenarios. I am very privileged today to begin the program by introducing Albany Law School's President and Dean, Cinnamon Pignon Carlarn. Dean Carlarn joined Albany Law School in July of this year and comes to us from the Ohio State University Moritz College of Law, where she was the Associate Dean for Faculty and Intellectual Life and the Robert J. Lynn Chair in Law. Dean Carlarn is a leading international expert in environmental and climate change law policy. She has quickly become an advocate for the well-being and advancement of Albany Law School students, faculty, and staff, and she has demonstrated her commitment to a collaborative, diverse, and inclusive community. She is a strong supporter of the work of the Government Law Center, including its collaboration with the Fair Trial Free Press Conference. And I now invite Dean Carlarn to say a few welcoming words.
Thank you. So to make sure I can hear, okay, good afternoon, everyone. I'm really thrilled to have the opportunity to welcome you to Albany Law School and to really help kick off this important event. I want to begin first with a few things. So first, thank you and huge shout out to our Government Law Center, including our very dedicated director and our deputy directors, so Judge Stein and Patrick Woods, who's right here, for all of their amazing work on this program. And also a huge thank you to Chell Miller, who is just a genius behind everything that happens. And a very special thanks to our moderators today, who are also, of course, two key players in the Fair Trial Free Press endeavor, the Honorable Albert Rosenblatt, and who is, of course, a retired judge on the New York Court of Appeals, and then Rex Smith, who is the former editor of the Albany Times-Union. So thank you to the two of you, and thank you to all of the panelists who are here today. And to those of you who've joined us, we have a pretty amazing group gathered. It's going to be a terrific conversation. This event really speaks to and kind of aligns with the mission of Albany Law School in many ways. So of course, as you probably know, our mission at the law school is to provide a really rich learning environment, to have a lot of rigorous and innovative academic programs in a setting that really advances all our thinking on liberty, justice, ethics, integrity, critical thinking, and the search for truth. And the conversation that's going to happen today really aligns with and advances that mission. So that is critical thinking, an emphasis on justice, and a focus not only on the search for truth, but also really importantly on the communication of truth. So hopefully this conversation will encourage us to think about how to advance communication and education within and across the distinct but very kind of intimately tied disciplines of law enforcement, and journalism, to think about how to really promote informed, balanced, and fair coverage of judicial proceedings. These are goals and interests that really advance critical thinking around access to, the operation of, and the understanding of our justice systems, topics that truly are at the heart of who we are as an institution and what law and legal education is all about and seeks to do. So again, welcome to Albany Law School, welcome to the speakers, and to all of our guests. We're really thrilled to have you here and really looking forward to an engaged and really informative discussion.
Thank you, Dean Carlarn. I also would like to recognize and thank a few people in addition to those already mentioned by the Dean, who were instrumental in making this program happen. The Government Law Center really consists of a team of very talented and dedicated people with a variety of skills and experience. And without each and every one of them, we could not be putting on the programs such as this that we have been fortunate enough to hold. Our staff members who have been intimately involved in this program include Richard Rifkin, our legal director, as well as Chell Miller, Lisa Rivage, does all things related to the CLE credits that you're going to get. Tamar Reiner, our GLC coordinator, which is no easy task, and the Albany Law School Communications Department. In addition, we have the Fair Trial Free Press Board officers and members, Judge Rosenblatt, Rex Smith, Mike Greigel, Diane Kennedy, Steve Clark, as well as Patrick Woods and John Gross. So today we are proud to present to you a discussion addressing the legal, political, and ethical issues that arise after a fictional gubernatorial candidate has been indicted on federal financial fraud charges and a turbulent trial ensues. Panelists will discuss the rights to attend and report on trials, including social media, gag orders, anonymous juries, police conduct, and protection of the press and its sources. You should all have received the hypothetical that they will be working from in your program materials. And you also have in your materials a full bios of our amazing, talented, experienced panelists, as well as our moderators. So I'm not going to take up any time regaling you with their accomplishments and who they are. Questions in the Q&A box. Finally, don't forget to submit your affidavit for CLE credit if you're seeking a credit, and your reviews of today's program. With that, I'm going to turn it over to Judge Rosenblatt and Judge.
Okay, thank you very much, Judge. This is terrific. I might add there are a lot of journalism students also, as I understand, paying attention here. So for you, as well as for the CLE credit hopefuls, I will be reading you a code word twice during this presentation. So you'll need to write down that code word to be able to prove that you were actually here. So we're going to ask these people at this panel to play certain roles. You're going to be called upon to put yourself into the place of folks in this hypothetical as we go through this, and Judge Rosenblatt and I will sort of alternate, and if he thinks of something that's very important to step forward and intercede with, he'll do that. And we will not read entirely to you this hypothetical because we will assume that you're reading it. But just broadly to explain to you what's going on here, this involves a very wealthy business person, a woman named Jamie Tusk, who has a privately held international real estate firm. You may be aware of people who are prominent in the world who have privately held international real estate firms who find themselves subject to legal action. Though everything here is, of course, how do we put it at the beginning of novels, entirely fictional, and any similarity to events and individuals living or dead is purely coincidental. And thanks to Mike Greigel for writing this hypothetical and leading us in this area. Tusk is such a successful and dramatic person that she has emerged as somebody with political influence and is indeed considered to be potentially even a presidential candidate for the United States. But there is some question about this. And she has sought a $500 million loan from a commercial bank, but her loan application seems to have had some erroneous information on it. So there is a U.S. attorney named Alex Gruff, who has convened a grand jury after an investigation that has indicted this real estate magnate on numerous financial fraud charges, including materially falsifying loan application information. Tusk, who is a great user of social media, took exception to that, of course, and called upon her many supporters to show up at the courthouse. I'm sorry, let me not get ahead of the story here. She's said that she's innocent. She castigates the U.S. attorney as moronic and unjust, says these are fake charges, there's a fake case, and Tusk has encouraged her supporters to attend her arraignment in order to protest her persecution by the federal government. So the U.S. attorney moves for a gag order for the duration of the trial. And you can read in the hypothetical what that gag order suggests. But let me just turn first, if we could please, to get this conversation underway, to Martin Bell, who earlier in his career was in the role of a prosecutor, assistant attorney in the Southern District of New York. And let me just ask you, Mr. Bell, as the prosecutor that you might imagine yourself to be here, the gag order, implicates the scope of the trial court's authority to restrict the First Amendment rights of trial participants. And this is especially true, of course, where you're dealing with a prominent defendant. You might offer what might be a justification for a gag order, and whether, in particular, in the 21st century, the nature of social media might play a role in whether you might be looking for a gag order at this point that you might not have thought of doing, say, 20 years ago when you were a prosecutor. Yes, you can. Please be candid.
There we go.
There we go.
More easily be candid when I can be heard. I'll be candid, Judge. I can't imagine applying for this gag order. The most important thing to the U.S. Attorney's Office is to put together a case and run it through the machinery of justice in a way that it will actually survive appellate scrutiny. And this seems to me to invite a number of issues that are not worth the price of admission, concerning the constitutional rights of the general public to not only their own speech, but to a fully public proceeding. We've got pretty thick skins, we public servants in prosecutors' offices and judges' chambers, I think, as well. And it is only we get used to, particularly in a place like my old office in the Southern District of New York, circus-like atmospheres reasonably often. It becomes old hat to the marshals, to everyone else who sort of puts up with it and ensures the safety of folks coming in and out. The only occasion in my 10.5 years on the job that I could remember anything close to this happening was an individual whose name I forget, who made it his business to hand out pamphlets encouraging jury nullification on the jury line just outside of the Daniel Patrick Moynihan Courthouse, and who also occasionally sort of threw himself down theatrically in front of the line of people getting into court. He was actually charged with obstructing, the criminal legal proceedings there. Short of something like that, we wouldn't see a gag order like this as worth the price of admission. Now, we certainly wouldn't do it unless we were the second movers, and perhaps there's an opportunity here for Tusk to earn a response of that sort if there are particular concerns about the jury pool, or if it is repeated conduct that meanders into the area of either a threat or publicity. I think the weaponization of social media really doesn't come into play until it's something that could affect people who are drawn into the process because they're simply observing their duty as citizens, doxing the names of individual jurors, that sort of thing. And that's conduct that I could imagine being worthy of this sort of application and some sort of judicial admonishment. But we, I think, generally see extra sort of procedural commentary, even if it encourages people to come in the courtroom and create disorder, as something that we would rather absorb than muddy the record with.
Well, let me just see if another prosecutor next to you, John Flynn, Erie County DA, president of the New York State DA's Association. Can you imagine such a gag order? If and have you ever moved for such a thing where you might have a defendant calling you on to millions of social media, an audience of millions of social media, moronic, the fake charges, persecution by the government? You think you might try to get some action there?
Well, I have never done it myself, but ironically, I have been the recipient of a gag order. As I think probably everyone remembers, unfortunately, about a year ago, we had a mass shooting in Buffalo, New York. I prosecuted that case, and the defense counsel in that case applied for a gag order to prohibit me from speaking to the media. And, you know, I found it a little ironic because if anyone knows me back in Buffalo, I only speak to the media after the initial arraignment on the case. It's my policy that I never speak to the media during the case. Once an arraignment happens, I then usually, for a high profile case, speak about the indictment, the arrest, the arraignment, and that's it. But in this particular case here, I actually violated my own principle for a number of reasons. We had the entire country, CNN, Fox, everyone was, at the courthouse. There were, numerous elected officials who were giving press conferences daily. The president himself, President Biden, was talking about this case. Governor Hochul, everyone under the sun was talking about this case and basically out there saying that, the defendant is guilty, he's a racist, et cetera, et cetera. And my concern was a fair trial. I wanted to ensure that there was a fair trial, and I was concerned about a change of venue. In our hypothetical here, metropolis, we can assume that this is a extremely large city in our hypothetical here. Buffalo is big, but not that big. And, I was very concerned about, a fair jury pool in the future. I was concerned about if too much was being talked about in the media, that the defense would make a change of venue, and I did not want that. So within a week of the arraignment, I gave a second press conference, which I never do. And after that second press conference, I said something that the defense didn't like, and they applied for a gag order, and I did not oppose it. I said, fine, I don't care. I don't need a gag order because I'm not going to speak anyway. But if you want to issue the gag order, judge, go ahead. I did not oppose it. And so there was a gag order in place throughout that proceeding. He ended up pleading guilty within, 8 months. And so once he pled guilty, the gag order obviously was lifted. But for that period of time, in a very high profile case, there was a gag order in place.
Do you think, by the way, during that time, do you think any of your assistants had any on background conversations with journalists?
No. No.
Rosemary Armao, investigative journalist with considerable experience. In your work as a reporter, did you ever have prosecutors on background speaking to you about cases pending before trial?
I did a lot of work in federal court and prosecutors sought me out. So did judges. And like my view is that everyone in the court system should answer all the reporters' questions right away, tell them everything they want. There'd be no problems at all.
Mark Mahoney, that's your experience as a reporter also? Have you dealt with prosecutors and defense lawyers who would speak to you on background perhaps without wishing to be publicly
Yeah,
identified?
I would have that to some occasion, but kind of just so you understand kind of things, not for anything that they wanted us to publish or to leak out so that we could influence the other side or anything like that.
Interesting. I'll tell you that I used to have DA bureau chiefs who would open their files to me actually with the understanding that it was on a source basis. So, you know, this does happen. Just for the young journalists in the room, I just want you to know you don't have to necessarily assume that the stance that Mr. Flynn is taking ends your opportunity to get information. But, you know, to the question of the gag order, Roy Gutterman, First Amendment expert here, would you say that it's permissible under the First Amendment for there to be such a gag order as this? And bear in mind, we have a contemporaneous experience right now involving this real estate magnate, whose name escapes me.
I think there are elements of this gag order that go above and beyond the propriety under the First Amendment. I do believe our target of this case, it does have some First Amendment rights to speak and to use social media. I also believe a court has an obligation to ensure a fair trial and safety of all personnel involved. My biggest problem with this gag order is the way it might affect the media. It's one thing to bind litigants in a case. It's one thing to bind a defendant in a case from speaking, maybe even a prosecutor. But to rope in the media as a potential liable party for this, I think goes beyond the First Amendment.
Does the media have standing to intervene to challenge the gag order?
If the media is named, I would say the media has an opportunity to intervene and at least put its argument on the record and perhaps even convince a court that the media should not be bound by this order.
In this hypothetical, Judge Blaine Justice, U.S. District Court, who was assigned the case, entered the gag order on an emergency interim basis. Judge D'Agostino, can you imagine a circumstance where one of your colleagues might do such a thing?
I can, but I want to begin by saying that I don't know if you know what it's like if you haven't been a judge to preside over a criminal case. I can tell you that my law clerks tell each crop of new law clerks that Judge D isn't the same when she's on a criminal trial as she is when she's on a civil trial. Because when I have a criminal trial, every day I'm saying to myself, I have to give this defendant a fair trial. And I say to my law clerks, on our watch, someone who did not commit a crime should not go to jail. So we have to be at the top of our game. So in terms of, you know, gag orders, there are a few things that I will say. First of all, you have to have and you have to state as a judge a very specific reason, in my view, why you are imposing any gag order in a case such as this. The seminal case is Nebraska Press versus Maxwell, and that case set forth three factors. First, that publicity would harm the defendant's right to a fair trial. So if you're a judge and you believe that, you have to make a specific record of it. Two, you have to apply the least restrictive means to enforce the gag order. And three, you have to demonstrate as a judge that it will be effective to ensure a fair trial. So these are the minimal factors that you have to state. And you have to be careful about prior restraint on free speech when you're issuing a gag order. And as you just heard, there's a big difference between issuing a gag order to the participants in the trial from a gag order to the press. many courts will issue gag orders for the participants in the trial and say, these are the things that you definitely should not be talking about. But a general gag order for the press not to be reporting on certain things could be very, very problematic. Justice Frankfurter made a statement years ago when he talked about trial by newspaper. And he said that as courts, we have to be careful to tear participants from their moorings of impartiality by the undertow of extraneous influence. But I can rarely think of a factual circumstance where I would just impose a general gag order on the press because I'm concerned about the defendant's rights. In the Northern District of New York, if you get on our website, you will see that there are specific things that we tell people who are starting a criminal trial. It's our local rule 2023. And we say that statements concerning the following subject matters presumptively involve a substantial likelihood that their public dissemination will interfere with a fair trial. And then we list them, prior criminal records, prior indictments, the existence or contents of any confession or admission statement that the accused is given, or the failure to make any statements, the performance of any examinations or tests, the identity or the credibility of prospective witnesses. I'm not going to read all of them to you, but they're right on our webpage, and anybody who's beginning a criminal trial can take a look at these and understand what is fair and what's not fair. I had a trial this year where it was being reported every day that the defendants were connected to the mafia. The M word never came up during the trial, okay? And I questioned the jurors beforehand. Have you read anything about these defendants? They all said that they had not. I have to assume that they were telling me the truth. And of course, we tell jurors every single day of the trial not to read any press accounts. And I'm a little bit naive. I mean, I do think the jurors try to follow that. So while the mafia word was almost like in every story, every day I'm telling the jurors not to look at it. So bottom line, a general gag order, a preemptive strike is probably not the best way for a judge to go.
All right, so we're not getting a gag order in real life here with this scenario. We can leave that issue behind. But what we're going to move to now is what happens at the scene when the defendant's supporters have congregated, a couple thousand of them, maybe more, and there are going to be clashes where there are violent outcomes.
The next chapter, I think we get this going.
How's that? At the next chapter of this fascinating hypothetical that Mike Greigel created, there's an arraignment. And as you might imagine, in a case of this kind with massive public interest at the arraignment, the supporters of the person accused, Tusk, show up. And surely, as one might expect and imagine, violence breaks out. Supporters against other supporters on the other side of it. The police come to the scene and there's a melee. The police then see the reporters at the scene. They believe that the reporters are getting too close to the melee action. And one of the police officers grabs the cell phone of one of the reporters and confiscates it, and also has the reporters move away from the scene and detains them at a location farther distant from where the action is going on. So that brings us to how we translate this from a hypothetical into what, at least through this session, would be the real world. And I'm going to ask, I'll start with counsel to the state police. whether whether the circumstances justified the seizure of Scoop's cell phone. I'll start with that question and ask the counsel to the state police about that.
Sure, yeah, if there was one paragraph that sort of jumped out to me, or these two paragraphs here was certainly this, what we're talking about here. The one thing we got to keep in mind, right, are police, what they're there for. Keeping the peace, making sure people aren't getting hurt, health and safety. And they're faced all the time with making split-second decisions, right? So in this instance, without more, I wish there were a little bit more facts in here, right? It's.
Well, you can add them.
I can add them. All right, well, great. She was using the cell phone to injure somebody else. In that circumstance, you're being arrested, right? And then you're getting, but in this case where it's just a.
To say that if she used a cell phone and hit somebody else over the head with it, that would be assault. We're not gonna let you off that easy.
Right.
Sure, if she hit somebody with the cell phone, take it away, right?
There's an
That's-
arrest.
that's
there's
too
a search
easy.
Incident to an arrest and you're taking the phone. right?
Yeah.
Instrument
Yeah, that's too easy. We're
But in
making
this
it tougher.
circumstance where we're just talking about, if the officer goes up and just takes the phone in that, again, in this circumstance, just like that, with nothing more. After the fact, you're talking about a problem, right? It's a seizure, you're taking the phone, there's no arrest associated with it. So you run into that. As far as the paragraph in general, like I said to begin with, the police are there, again, health and safety, they're making split-second decisions. In today's world now, it's very easy to say after you see a camera, body cam, people with cell phones, making those decisions, getting into the mind of the police officer at the time is really what we're talking about in terms of what's reasonable in the totality of the circumstances. This alone right here, where he just walks up and takes the cell phone of somebody, I think you'd have a problem after the fact.
Yeah, I think a lot of people would agree with you when you say there's a problem. Is that another way of saying that there's no right to seize it?
Again, in these circumstances, I would probably, without anything more, certainly no arrest associated with it. Yeah, I don't think you have the legal right to seize that phone.
All right, so on the one hand, if she uses the cell phone as a weapon and hits someone over the head, yes, seize it. But in this case, no seizure. Other than using the cell phone as a weapon, are there any circumstances that you can hypothesize, make up any fact you can, in which the police would be authorized to seize a cell phone from a reporter who is not using it as a weapon to hit someone over the head with? That's a tough question.
Sure, I think it is a tough question. I think it's in this fact pattern, I think it's going to be really hard to get there. I mean, if there's an ongoing investigation into the reporter, understanding whether or not there's something else out there, meaning she's using a cell phone to commit any number of crimes that, could be appropriate.
For example?
Obviously, that would be wire fraud. I mean, any number of federal crimes that could be, available, or state crimes, obviously, but.
How could she commit wire fraud using a cell phone reporting? Where was the crime?
This is my hypothetical would be, in order to get the cell phone, there would have to be other facts associated, but in this one, I don't think.
Oh, like saying, okay, using the cell phone, saying, lying and urging violence. Okay. All right, well, I see you're shaking your head. Yes, go ahead.
Oh my God, I'm outraged. This is like double First Amendment violations against freedom of the press. That is a reporter at a newsworthy, important event, gathering news. And second, it's a violation of, well, okay, that's enough to begin with. It's an increasing problem. We're seeing it. The police don't have to be effective. There's no way they're going to win this case. It will be thrown out. There will be no charges, but the police will temporarily remove reporters from the scene so they can't do their job, which is what I think they really intend to do. And that must be fought. If I were that reporter, I'd be borrowing anybody else's cell phone I could get, calling my editor and send 8 other reporters down here. They're keeping us away. I would cover it doubly as much, and I bring a case later because that is a violation of my rights to report. I think this is a case where the legal profession is trying to protect police who are not doing their job, who are just really, right to protest, of course, that's the other First Amendment right. It's the people who are there are also not getting fair coverage, or their protest is being made less effective because you're shutting down the press. I think it's just inexcusable. Wire fraud, come on.
I would grant you, I'll grant you that seizing a cell phone with no reason other than the fact that she was reporting would be antithetical to the First Amendment. The cordoning them off is a different question. And were there any, can you foresee any circumstances in which the police would say to the reporter, look, you know, you're right in a line of fire here. You know, just you want to step back because there's violence breaking out. So you can cover all you want, but I want you to stand 15 feet away. Is there anything wrong with that?
No, and that's typical and obeyed by any reporter. If you're at an accident scene, a police scene, a criminal scene, you expect that. If you're smart, you come in early before those cordons are set up and you get around it and you bring in another reporter who can sneak around them, but you do pay attention to it. And you take your lumps. If you go across a line, a cop or a firefighter is gonna chew you out and cut you off and you accept that. But that's not what's happening in the country right now. What we're seeing are Black Lives Matter protests where reporters covering, doing their job on an important story were being shut down and arrested. No charges against them later because you can't charge them. They're not doing anything wrong. It's all designed to get them out of the way.
So what's the remedy? Shouldn't there be a remedy of something akin to false arrest or false detention?
Yeah, I actually would like, our media is increasingly weak. We don't even have a lot of reporters, much less legal power. But yeah, there should be pushback against this against the police departments. The worst case was in Marion, Kansas recently, where city officials basically didn't like a report that went in the newspaper, so they raided the newspaper office and the home of the publisher, took material. It was all thrown out. It's getting scary. That should not happen, even close anything to that happening with our First Amendment, and yet it is. Mark, go ahead.
Yeah,
Please.
it would seem to me that that their primary objective should be to keep the media from interfering with them doing their job. I don't know how much of an obligation they have to keep the press safe if the press wants to put itself in danger. The word that jumped out at me was detaining them, you know, pushing them off to an area, not just where they couldn't see what was going on, but also kind of forbidding them from leaving that area or whatever. And also taking away, not only is the phone, you know, a camera that they could use to record the news events, but it's also their form of communication. So it just seems like that they crossed the line too far in terms of they got the reporters out of the way of them, you know, controlling the crowd. But it seems like to me as a journalist that that's where that should stop.
Let me ask the professor to weigh in on this.
Reporters are never going to win a fight or a battle with police at the scene. That much we know. And the only real mechanism is educating law enforcement about the role of the press, the rights of the press in a public place. And the only way to enforce those rights would be an after the fact, some sort of after the fact litigation. Obviously to get any sort of charges thrown out, but perhaps even a Section 1983 claim later on for abuse of a civil right or a First Amendment right. And enough of those add up and law enforcement will, you know, the next time this happens, perhaps a law enforcement officer on the street is going to say, well, you know what, I might get in trouble. I get the department sued because I'm arresting somebody for no real reason or taking their phone or anything like that. One other thing to add, in addition to calling your newsroom, you're gonna have to call your lawyer and you're gonna make.
Yeah.
I want to ask the judge about this. Yes, they now come before you. The reporter comes in and said, Your Honor, they grabbed my cell phone. What's my remedy? Of course, they come in with a lawyer and make a motion, but can you just craft out how you think this would play out?
Well, I'm thinking about potential litigation, and this fact pattern really alleges a Fourth Amendment violation, a taking of the phone, you know, with no probable cause. And I had a case many years ago. It did not involve the press, but I think it's timely for the discussion that we're having right now. I had two groups in a municipality, a Jewish group and a Palestinian group protesting. Well, actually, one group was having a picnic and a party and a celebration, and one group was protesting. The municipal police department decided that people were getting too angry at each other, So they decided to move the protesting group behind a garage and where they couldn't be seen. Prior to that, they were on the street, public street, the entrance of a park with their placards saying what they wanted to say. And the municipal police said, well, no, tempers are flaring. And they ushered them literally behind a garage and told them that that's where they could protest. Now, they weren't the press, but it's analogous because that group brought a lawsuit that was in front of me. And it was based upon free speech and, the right to free assembly. And, I settled it the morning of, but it was kind of like, Houston, we have a problem for the police because these folks had a right to be protesting where they wanted to be. As far as a 1983 action, yes, you could bring it, but there's this thing called qualified immunity, which I'm sure any municipal police officer would say, I wasn't aware that when I told the reporters to move and to back away, that I was violating a clearly established right. I was doing that because I feared that there could be disorder and that there could be a protest of some sort. So yes, those lawsuits can be brought. I don't know precisely how successful they would be, but that is one way that the press could deal with being handled like that by a municipal police force.
Is there
How
a
would
way
you
for,
see the I'm sorry, go ahead.
yeah,
Mike.
is there a way for the press at the scene to overcome this? Everybody's talking about, well, afterwards you sue the cops, but what can you do at the scene to free up the reporters? You said, we all know is that you stand behind this barrier and they're not going to let you pass it and we're stuck there. But what can you do to immediately to free up the press so that we can continue covering the event and that we aren't put in a position of being detained and losing our equipment and that sort of thing?
Wow, you're talking about disobeying an order of the police, which we know in retrospect was invalid, but that gets us into some deep waters. What do you think about that, Your Honor, on as far as would a 1983 action work under those circumstances if there was resistance by the press saying, I want my camera back, and starting to fight with the officer, give me back, you have no right to take my camera. And we know that the police officer had no right, but can she go to the police officer and start a tussle with him? That's a whole different question.
You can, but you have to live by the facts of your case. Like we have many 1983 actions involving, for example, incarcerated individuals who will admit that they may have made the first move toward a corrections officer, and then the corrections officer responded, or it could be the other way around. The corrections officer will say, yes, I did hit that incarcerated individual, but then he viciously attacked me. So the fact that both sides made an affirmative action does not mean that there cannot be a 1983 action, but it's kind of like that old philosophy that if you started it, you may be on the losing end, but a jury would listen to that. I think a jury would listen to that. And cell phones, someone takes your cell phone, your whole life is on your cell phone. So I would think that juries hypothetically would be interested in if they had a case in front of them, but you also have to have an injury. And I don't think this is a big thing that I'm not, I get the taking of the cell phone is a constitutional injury. It's a violation of the Fourth Amendment. So I think that you would have it there. Yes, you could bring a 1983 action.
All right, so that's a lawsuit, and that's a complicated lawsuit. By the time it got adjudicated with a jury and then an appeal to the Second Circuit, we're talking about maybe 5 years. And she's saying, I want my cell phone back. So there's a lot of fancy talk about 1983, but I want my cell phone back. So Professor, how would you go about?
Can I jump in? Because
Please.
Mark is right. It's the reporter at the scene wants some sort of relief. And increasingly reporters are disobeying their own lawyer's advice, which is you have to do what the police say, and they're not doing it. They're jumping out of the cordons. They're moving around. They are reporting anyway, and then going into court later and facing the charge. Especially in this case, why are the cops covering their badges? and they're taking away cell phones. There's a real story here that would go on my front page about police misconduct.
Well, ask
It's
Inspector
too-
Dirienzo about this because New York State Police, there is in this scenario, a cop has been assaulted. A cop got hit on the head by a sign. Cops are under attack. And maybe if your job is to protect the public safety, that includes the intrepid reporter who's put herself in the line of fire. I think Sarah Scoop is the name of this reporter here, not Rosemary Armao. But in any case, would you, in moving reporters to another position, when Rudy Giuliani was mayor of New York NYPD often would do that. They would move reporters aside, arguing that it was for their own safety. Isn't that possible? You might do that?
So first, as far as the name tags, I can only talk on behalf of the New York State Police, and we would never cover our name tags. It's not allowed. It's a violation of our policy. So that's the first thing. And the second, where the police officer was struck in the head by a sign, and then he responded by hitting the protester with a club. So, that kind of, it's very vague, like what kind of sign was it? Was it a, paper type sign, or was it like a big 2x4 with nails coming out of it? I mean, there's a big difference here, which we don't really understand. And so that it depends on, your use of force, or what's reasonable, what are you justified doing? So there's that. And as far as moving the reporters, no, they're allowed to be where the general public should be. We have to maintain the integrity of whatever crime scenes and preserve evidence. So there can't be any interference with that. And as long as they're not interfering with our active investigation, they're allowed to film, and that's just the way it should be. So I don't see any, issue with them being there and moving them away. I mean, that's just going to cause friction. And
Natalie wants to say something about the gag order.
I would add to, as
Excuse me, let me just say a word for a second, for people at home following along. If you're seeking CLE credit or journalism credit, code word number 1, write this down, folks. If you want credit, code word number 1 is subpoena. SUBPOENA, journalists. Okay, please, go ahead.
As the chief federal law enforcement officer of the region, and someone who has the ability to prosecute criminal civil rights violations, were officers to have turned their name tags around prior to an event like this, it would make me more likely to investigate what had happened and would jaundice my view of their intent going into the incident. Were any individual officer to take actions beyond the realm of what was necessary in order to maintain order.
It's just take the other side of that though, first for a minute. I think that most police agencies in New York State now have a policy about not covering up your name tags, but there is a reason why officers did it. They did it in Buffalo during the George Floyd protests that occurred, because when they were out there, there were individuals who were taping the police officers and taping, recording their names and then going on social media and posting where these police officers live, their addresses and whatnot. And so it was a safety concern for the officer and their family. That's why I believe some police officers cover their names up over the years. So I'll push back a little bit on if there's any kind of nefarious conduct on the police officers automatically by covering their name tags up, when in reality, the real reason probably was that they were protecting themselves and their family. So I'll stick up for the police in that regard.
Natalie Brocklebank, the Public Defenders Association, is that persuasive to you?
No. Let me say that again. No. Obviously, there is police accountability in all of this, but certainly, from the perspective of you know, if I'm representing one of the maybe journalists that have now been taken into custody and is being possibly charged, and my cell phone has now, you know, their cell phone has been seized, and the officers involved in this were concealing their identity, and there is no way to figure out, you know, what body camera do I need to make sure that I am receiving through the course of discovery, because I don't even know what named officer may or may not have been involved, and I can't necessarily rely on just what I might be receiving. There could be, if there's multiple officers involved, there could be some body cam footage that is, you know, capturing parts of the event that are certainly important to the allegations that my client might be charged with. So I think that certainly it's important to ensure that, you know, there is police accountability, and that if officers involved in arrests are making sure that their identities are not concealed. And I think that is consistent with what the law provides as well.
John, let me ask you this. Is there a policy in the state police for one of these two eventualities? One, is there something written down in the state police manual about when, if ever, they're allowed to conceal their name tag? And secondly, is there some policy written down for the state police as to when they can grab a cell phone, or is it barred totally?
Well, I guess I'll take the first one. Yeah, I mean, these circumstances,
Speak a little-
given this fact pattern, yeah, there's no scenario where seizing the cell phone without more is proper. Certainly not here. As far as the name tags, in New York State right now, there's been a push, certainly since 2020. In some circumstances, to make it a misdemeanor for law enforcement officers to cover their name tag, or generally to ban it. It hasn't passed yet, as far as I know. But as far as state police in general, no, we don't cover up our name tags. It's part of the uniform, and it's not something that you know, would certainly be allowed. If they did, you know, there are administrative ways about fixing the problem.
So even if it turns out that people are photographing their name tag and then going online, finding where they live and making trouble, it's still state police policy not to cover it.
Yeah, I mean, that happens all the time now, certainly with, you know, cell phones out in the public. I mean, unfortunately, that's the world we live in. And to the DA's point, you know, that is certainly the reason why in some circumstances law enforcement have done it, right? Nobody wants anybody showing up at anybody's house. But it's certainly not their own in terms, you know, you have family members, and obviously with internet and doxing and the ability to quickly get a hold of, you know, so the reasoning there it is just like the DA said, you know, would be the justification for them to do it. But obviously, as far as I'm concerned, and you know, within state police, we don't allow that to happen.
As far as in the training manual and the training sessions, are the police trained to not take cell phones, or you're just silent on it and there's an inference that they shouldn't do it?
The law was passed recently, I think maybe last year or the year before, with respect to the ability for any member of the public to have their cell phone out. And just like the inspector talked about earlier, the only circumstances when it's any law enforcement officer should be taking a cell phone in any circumstance is if they're obstructing, right? If they're getting in the way of an arrest, or getting in the way of, you know, public safety, or putting other people in danger. That's the only scenario where that would be.
They're using it for some criminal purpose.
Correct. And
Right.
you know, someone's just using the cell phone to video, or, you know, make a call, and there's no circumstance there, you know, short of, you know, obstructing or again, committing some other violation, then it would be appropriate to take that cell phone.
All right. Though it happens across the country, not necessarily in New York.
Not by New York State members.
Right, okay. So continuing on the scenario here, we have reporter Scoop, who publishes a story about the defendant's lavish lifestyle to a Caribbean retreat, seemingly financed by these illicitly obtained funds. And this includes surveillance photos. I wonder who might have taken those. So this story appears, which prompts the U.S. attorney to file a motion asking the court to convene a contempt hearing to ascertain who had violated the gag order. And reporter Scoop is subpoenaed as the key witness. So before we go to the counsel for the journalists here, let's just ask our federal prosecutor the circumstances under which you might be able to subpoena a reporter to find out such matters.
They are extraordinarily limited, if existent at all, and I wouldn't do this either. We have had occasions at the Southern District where there have been leaks by what we imagine to have been law enforcement, because who else has the particular information, to members of the press, and they've been concerning. They're particularly concerning, for example, in cases where they would tend to violate grand jury secrecy. In federal criminal law, there is this thing called Rule 6E that keeps materials that are being submitted actively to the grand jury a secret from the rest of us. It allows those investigations to happen. It does so while protecting the reputations of people on the outside. It has a number of important functions. And there have been times where grand jury information seemingly was leaked out to the public. Our answer to that tends not to be to get a court involved at all, but rather to do the thing that federal law enforcement ought to be pretty good at baseline, which is investigate on its own, outside the realm of some sort of gag order, and do so from the law enforcement end, and ferret out to the extent possible from the law enforcement end who did this. To do so the other way, to start subpoenaing reporters without having exhausted other possibilities creates the very likely possibility of a debacle of constitutional dimension, and the sort of thing that would get that very table justifiably very loud, and is not and the sort of thing where, were it to translate into any sort of legal action, be the sort of thing that would likely turn into a rebuke, judicial or otherwise, for my office, which we don't want. So there is, of course, the possibility that your investigation of who was behind the leak might not be as effective if you're not able to get at the reporters. To which the answer is too bad. There are other concerns here.
Wouldn't there be some suspicion about the U.S. Attorney's investigation of the leak if the material in the story includes surveillance video that presumably was in the custody of the U.S. Attorney? So there might be some suspicion, if you're investigating this, that you're probing your colleagues.
There might be. I think that the only thing that we could do, were this to find its way into a public forum, or were somebody to make a public statement, is to state emphatically that that sort of leak is unacceptable, that we are looking into it using all permissible means, and that the people who are involved face any number of fates ranging from disciplinary action to something stronger.
Couple of people on this side of this are going to be interested in this. And we'll get to the judge in just a moment, because he's going to be interested, even though we know Judge D'Agostino wouldn't have signed this this gag order in the first place. Let's assume that someone else did, and maybe you're reviewing it. Maybe it's a judge below. But let me just hear from Roy Gutterman first about this. Is that does the reporter have a privilege that will provide a basis for the subpoena to be quashed? And if so, what's the source of that privilege?
Well, I'd like to make a lot of noise on this, actually. I can't get to the courthouse fast enough with my motion to quash. And again, we're in a federal jurisdiction. So we're going to be somewhat limited with our rights. If this was in a state court, we'd march in with our New York shield law and get this thrown out probably before the stamp was even dried on it. I would make the argument that yes, we do have a privilege here, maybe not a total privilege under the First Amendment, but a right under the First Amendment to conduct news gathering and do our job. I would also point out that I would say under the facts of this scenario, the Department of Justice appears to be violating its own internal rules on subpoenaing reporters. They can't just go willy-nilly to the reporters because they want to find out who the source of a leak is. So I would point to that as well. And I would point to our only precedent on this from the Supreme Court, Brandsburg v. Hayes from 1972, which does set out some standards for what the government's going to have to prove to get a reporter to testify or to reveal confidential information. And to quote or to paraphrase Justice Powell, the concurring opinion, and Justice Stewart in his dissent, the government is not free to annex the press to become its investigative arm. I would think that the Department of Justice and the U.S. Attorney's Office would have more than ample resources to find out who the leak was without knocking on our reporters' doors, and therefore invading our right to use confidential sources or any sources for that matter.
Judge, are you good with that? Or if you want to find out, however, who violated this court order, and the quickest and surest way to do that is to compel the reporter to tell you who gave her this surveillance video and all this information. Yes.
Of course, every case is different, but the case law is pretty well settled in this area. And I'll just speak for myself and not specifically on these facts necessarily, but say that the government would have a lot of explaining to do to me before I would haul a reporter in and require that the reporter give a source. If it were an exigent matter, if somebody's safety, was at risk or something like that, maybe, but with the might of the government as it is, I would think that we would not have to get to that rather extraordinary action, and that they could do their own investigation. And of course, in a case like this, where the person is a public figure, almost anything goes with what you're going to print about a public figure, unless it can be demonstrated that you have actual malice. So speaking for myself, it would take a lot in order for me to require by order a reporter to come in and to disclose a source. I'm not saying it could never happen, but in the theoretical world, it would take a lot.
I'm a little bit troubled by the nature of the alleged violation of the gag order, because under the hypothetical, the U.S. attorney is making a motion for a hearing as to who violated the gag order, and the violation seems to be that Scoop is laying out the details of the prosecution's case and a retreat showing a bunch of pictures. How can I violate, I'll ask the U.S. attorney, by the reporter laying out the details of the prosecution's case? Is that a basis to hold a contempt hearing for violating the gag order? Or am I reading this right?
Again,
Mike, you could speak out also. I'm just puzzled by whether this could ever be the basis for violating a court order with the reporter lays out the prosecution's case. How in the world could that be a violation of anything?
I'll offer something. There is a reason why at virtually every press conference I've attended or been a part of while at the U.S. Attorney's Office, the U.S. Attorney himself and anyone speaking on behalf of the government have been extraordinarily cautious to limit themselves to the four corners of the instrument that's being introduced. That is to say, the complaint or the indictment. Why? Well, one reason is that if you lay out the government's case, even though it will presumptively become public later on, and this assumes a world, by the way, where we're not even talking about a gag order, right? We're just talking about what's inherently potentially problematic about this. You could lay out that evidence in a way that is selective and in a way that tends to influence or jaundice the pool of prospective jurors against the defendant in a way that is somewhat skewed. You're not going to present the entirety of a case in a press conference or in remarks or through whatever leak may have happened here. And doing so in a way that would tend to leave people thinking, oh, well, this guy's guilty. Outside of a forum where there are checks and balances in play, not to mention evidentiary rules, is the sort of thing that could be seen as undue influence of the prospective jury pool. Not to mention, if there is still an active grand jury matter, and there are grand jurors who could be swayed by this in advance of considering a superseding instrument, if they're going to add charges later on, this is something that could potentially be harmful there as well. My old boss at the U.S. Attorney's Office got into some trouble just for characterizing these offenses.
U.S.
as
Attorney's
ba-
Office.
Yes, as
Sure,
bad.
but we're talking about the newspapers, whether
Oh.
the press can write selectively. Mark, you look a little bit uncomfortable. I cannot imagine why you'd be uncomfortable with the idea that the press should be shaped as to how and what they emphasize in an article.
Right, it's not our responsibility to give the prosecution the opportunity to present its case in full, and it's just our responsibility to present the news as we see fit. And the consequences of that, while we'll be aware of them, I don't think that's a function of our existence is to do that.
But
To be-
potential jurors read what you write and it's inflammatory and potentially not
But whose
accurate.
responsibility is it to protect the case from jurors learning this information or acting upon it? Isn't that upon the courts to deal with them?
Well, we can't unring a bell, though. That's the problem. And, when I say, have you read anything about this case? And if they really want to be on that jury, no, I haven't read anything about it, but
then you can start, then I think that sort of opens the door to other restrictions on the press that, it's a slippery slope from saying, okay, something you wrote might influence a jury. You implied that this is guilty, or you interviewed somebody, a witness or somebody who thinks that the person is guilty. Are you going to go after each kind of quote that they get, each kind of bit of information that they get from other sources in order to protect the integrity of the jury system? How far do you go? And I think that opens the door when you start doing that.
no, I understand what you're saying, but I responded because you said, well, we can
For whatever we want.
we want.
Right.
But I'm just pointing out that it can have significant ramifications for someone to have a fair trial down the line. I'm not hunting out reporters pre-trial, to put you in jail or anything. I'm just saying that the more accurate you are and the less speculation, the better in terms of what I have to do, which is try to find 12 people who can decide the case fairly and impartially.
But that's not our issue. That's
get
not our
it.
problem. You know what I mean?
Yeah.
It's yours.
Let me ask Professor
Mostly it
Gutterman.
would be- Mostly it would be nice if you could find jurors who had read anything in the press.
I'll ask Professor Gutterman, putting aside the question of whether you're in a federal court that does not have a shield law or in a state court that does, putting that question aside, are you uncomfortable at all with the notion of subpoenaing a reporter based not on privilege, but on self-incrimination? Just take her and throw her in the witness stand. Isn't there a Fifth Amendment issue here? Couldn't she go to jail if she doesn't want to answer?
I mean, that's the ultimate question with, when a reporter refuses to answer a question or refuses to comply with a subpoena. I don't think I've seen arguments to be made for the Fifth Amendment, self-incrimination argument. I don't think it's really built up too much steam with media or reporters. So that would be a tough one. And that, and again, we can't make an inference from invoking the fifth, but I don't think it would look good for a reporter when there are stronger arguments to be made. Again, there's certain gaps here in the facts. We don't know what the sources were for the story. Many reporters will do a pretrial story where they don't even talk, they don't get any real comments on the record from anybody involved in the litigation. So they'll reconstruct it, talking to a bunch of outside lawyers or professors. Should reporters be held in contempt of court because they talk to a bunch of law professors in advance of a story? I think that would be a hugely problematic standard to establish in any kind of case.
Let's suppose that we're not asking the reporter to reveal sources, but the report is being subpoenaed and is being asked about herself violating a gag order, not talking about sources. Doesn't that raise a Fifth Amendment question?
But why would you need to ask the reporter if they violated the gag order when the implication is that the reporter already violated the gag order?
Can go to jail.
Correct.
It's in contempt, right?
It would be contempt if you don't answer a question, correct?
Yeah.
And I think that would be an argument to stick through and hope you can win that on appeal after you get out of jail in 80 days or however long you're going to be in jail.
It's also just ineffective because for most reporters, or at least the best reporters, going to jail is a badge of honor. I protected my story and my sources. I'm going.
Cold and uncomfortable.
Based upon the scenario here, though, how the reporter can't violate the gag order. The gag order just says that the attorneys, the parties, are prohibited from disseminating information to the media, et cetera, et cetera. It doesn't say anything about the media not saying anything here in the current
I
scenario.
think in the scenario, you're right. It's not the reporters who are gagged. It's the,
Correct.
yeah,
So that, I mean, in this hypothetical here,
right.
the presumption is that either the defense attorney or the prosecutor violated the gag order by leaking the only way that the details of the prosecution case, the only way that could get out is from the defense attorney who has it on discovery or the prosecutor himself. And so Gruff here is making a motion. Either he's a great actor or he's making it because he believes that the defense attorney violated the gag order. So again, I don't think it's right here what he did, but that's the premise here of what he did. The premise here is that Gruff believes that the defense attorney violated the gag order. And I agree with my colleague here that the better way to do that, find that out, is to make sure that it was the defense attorney and not anyone from my shop by doing an internal investigation.
But the defense counsel for the defense, you're going to be interested in finding out who violated this gag order, because actually it's detrimental to your client, this information that's out there showing her living this lavish lifestyle, right? So you would probably be joining in the effort to find out who leaked.
My client is also the one, right, in this hypothetical that was tweeting, saying, okay. So I guess to start off, I hope I never have a client like this ever. And I've never had a client like this ever, because if we are in a situation that the subject of the gag order is because of the defendant themselves, then I think the first question as counsel is, how did we get here? Because when you're advising your client in private about, your in the course of your representation of this case, the first thing you are doing is making sure that your client is silenced in all communication. And if you have a client that has gone rogue and is on Twitter and is on social media and is being very inflammatory about the facts of their case, you have a problem, right? But given this is the context of our hypothetical, and we are at this place where we have a rogue client and they are subject to the gag order. Certainly, if now the question is someone leaking facts about the gag order being violated, I would be all the more concerned that the court is not going to reflect poorly on my client because of the prior inflammatory statements.
Just curious, Judge, do you imagine there could be any, being a non-lawyer, I should know the answer to this question, could there be penalty imposed upon defense counsel if the defendant is doing inflammatory work, violating a gag order, for example? Does defense counsel have, in effect, a responsibility to keep her client gagged? Or is there recognition that that's rather impossible?
It's a pretty impossible task because I really should not be invading attorney-client privilege and saying to a defense attorney, I need to know what did your client call the Times Union and tell them that? Because it seems to me that he or she is the source of it. That's be very difficult. I really should not be invading that attorney-client privilege.
And with respect to the potential Fifth Amendment issue for the reporter, if the reporter, again, outside the hypothetical, perhaps illegally enters a chat room, for example, or accesses electronic information in order to get information about Tusk, our business person. If the source of the information might have been, in fact, a reporter's extra legal activity, do you have any way to defend against that, presuming the reporter might have confessed to you, well, yeah, actually, I did go into that website?
I wrote my law review note on this topic. The news gathering rights of a reporter don't unfortunately exceed the rights of anybody else to gather news or gain information. And I would certainly counsel a client or a media entity to not engage in illegal activity like computer hacking or any sort of actual trespass. I believe it would be a tough argument to make to defend some sort of actual hacking or any illegal activity like that. But if a source had engaged in that sort of behavior and then given that material to the reporter, that would be a perfectly legitimate use under several cases that have been argued at the Supreme Court. So I guess it all depends on who's breaking the law. Hopefully it will not be my reporter, but I'm not going to go as far as to ask the reporter right now if that's something that they've done.
In terms of breaking the law, I'm glad you used that phrase, breaking the law, because when we think about breaking the law, we appreciate that the attorney-client privilege does not contemplate its existence in the face of law breaking. So let me ask you this. Let's suppose, Natalie, that you cautioned your client, Tusk, said, look, there's a court order out there for a gag. Whether you're allowed to say something, you're innocent, this is an unfair trial. Well, I'm not talking about that, but don't you dare, are you listening? Don't you dare single out a witness and intimidate that witness. And he says to you, I'll do whatever I want. He then gets charged with contempt for violating a court order for Tusk. He's looking at contempt for violating a court order for knowingly threatening and intimidating a witness. You now get called before the grand jury and are asked whether you had a conversation in which you told Tusk not to do that. Where do you stand on that?
Well, first of all, we have a conflict, right? But
Conflict, what do you mean?
we have a conflict because if I am being forced to be a witness against my client,
Right.
that is obviously an inherent conflict.
Right.
I would first, though, try to argue to the court why I couldn't be compelled to testify against my client, because we do enjoy the benefit of attorney-client, confidentiality. I think in a situation in which there was some public acknowledgement, not through the course of my communications with my client, but if I was present during a court order in which it is now being called upon as a new subsequent charge, there could potentially be situations in which the court would require me to get out. And the court would find that there is a conflict and they would have to appoint new counsel. Whether I continue to potentially be a witness against my own client, I think is a separate argument that obviously we would seek to preserve and make sure that I could never be a witness against my client, because that's just not possible.
What do you mean it's not possible? Isn't it happening today? All over the country?
I mean, I think it's a very fact specific situation. It's a very, very, very potent attorney-client issue. And so I think that there would have to be clear circumstances in which the attorney would be a witness against their own potential client, and it wouldn't encompass only communications during their own attorney-client relationship.
It's happening today only when the attorney is a defendant now. I mean, that's where you're seeing it today. I mean, you're seeing it today, and I mean, outside of this, I mean, you know, in the real world, you're seeing it when the attorney themselves now has become a defendant, has charged against them, and then now they are turning on their client.
Good point. Now, I may have been mistaken. It's happening all over the country. But let me ask you, Professor, aren't there instances in which lawyers are being called before grand juries and being ordered to testify on the basis that the attorney-client privilege does not work for criminal conversation?
Yeah, I mean, this aspect of professional ethics and legal law, a little outside my area of expertise, but I read what's been going on in at least 3 or 4 jurisdictions around the country, and I do remember from my professional responsibility class that lawyers can't be engaged in breaking the law, even with their clients. So, you know, the crime and fraud exception, I think, is playing out or has played out in a number of cases that we've seen in relatively real time.
Interesting point. So if you counsel Tusk, don't you dare do that. You're not breaking the law. It's not a criminal conversation, you would say. But if you said, go ahead and do it, now you're a target. Now you're a defendant, right?
Arguably, yes. I mean, if I'm
Arguably.
advising
Interesting
my
distinction.
client about the repercussions of their conduct and that they should not do that because their conduct could potentially, you know, get them held in contempt, then that is certainly covered by the attorney-client privilege. But if I'm saying, go out there, do some criminal thing, and I'm got you covered and encourage criminal conduct, then I think that's a different story and that's a different analysis.
Right. You could be a witness, also a defendant. Is
Okay,
that right? Am I correct on that?
I'd agree with you, Your Honor. Yeah.
real life. So another item that in this hypothetical potentially matches real life, it has to do with audio, video, visual coverage of the court, which in this scenario, Attorney Watchover here is trying to get television coverage, but of course, in federal courts, the current standard is that federal court rules do not allow TV coverage and would interfere with the administration of justice. But defense counsel here is joining with the media. And so I guess the question, as a First Amendment expert, Professor Gutterman, do you think that there is in fact a First Amendment argument you could make on a right to audiovisual coverage of a criminal trial like this?
I will certainly make the argument. I don't know if I'll be convincing enough to a federal court, because if there's one thing that federal courts tend to agree on from the trial level all the way up to the US Supreme Court is that they don't want cameras in the courtroom or anything that could be used to record. On the other hand, I would say there's no greater way to involve the public or educate the public about what goes on in the judicial system than having audio and video, at the very least audio. We've seen the Supreme Court move on same day live audio. There have been some federal jurisdictions, some trial courts that have had pilot projects on cameras in the courtroom, but those were civil cases. So, you know, the administration of justice does require public understanding, and I would say there's no greater way to educate the public than having cameras right there.
Well, and of course, the constitutional right to public trial, citizens who might want to attend the trial and can't fit into a small courtroom are excluded. And moreover, citizens would be forced to rely upon spin doctors and the masters of mendacity at Fox News to tell us what's going on in these trials. Judge, can you imagine a scenario under which you could say, you know, in my courtroom, you know, there's state precedent for this when Judge Joe Teresi in Albany County allowed audiovisual coverage before the state law formally embraced it, right? Could you see a scenario in which you would allow the coverage notwithstanding guiding precedent, I guess, from federal courts?
Well, with the guiding precedent being the way it is, probably not. If I even contemplated it, I'm quite sure that I would address it. Like if I knew I was going to have a very, high public interest trial, if I even gave it a smidgen of thought in advance, I would talk to Washington, I would talk to the Second Circuit, but I'm pretty much bound to follow the prevailing rules at the present time. But I will tell you, it's interesting because it has come up since COVID, since we did do some proceedings remotely. I have had reporters and other people email my office and say, I can't be at that sentencing. Will you do it by Teams so that I can attend it by Teams? And I know this answer will not be all that well received, but the answer is my courtroom is open. It's open to the public. You come on down. And I will tell you that I do have concerns about people that I don't know having even the remote feed, because I don't know if they are recording it. I don't know if they mean harm to anyone. Well, I wouldn't know that even if they were in the courtroom, except that perhaps my court officers could perceive a problem. So, on a personal level, I am I think that civics wise, it would help people if they could see our trials. I think it would make people respect the judicial system more than they do. But I grew up in the O.J. Simpson trial era, and I saw a lot of things that bothered me during that trial. And I wasn't a judge then, and so I can say that I saw a lot of things that didn't make me proud about the way some of that trial was being conducted. But personally, and I can't make rulings on personal basis. I think that it would be very good for our young people, our citizens, to see a trial. And right now in the federal system, it's not possible.
Isn't that reaction, though, part of the sort of educational value? Like the OJ trial, you see what happened and you form an opinion on it. And some of it's not the sort of thing that warms the cockles of one's justice loving heart, but you know that this is the way that things work in state court, that judges are fallible, that trials sometimes get out of control and run half a year longer than they should. That judges sometimes get run roughshod over, and that sometimes issues. I mean, that's part of the civics education, right? Not just the sort of Schoolhouse Rock style 3 branches of government sort of thing, but more sometimes it goes wrong. Here are some of the wrinkles, and get to watch them happen in real time.
I mean, I'm on the record. If you watch my Senate hearing, my confirmation hearing, Senator Grassley called me on something that I had said 20 years before my hearing, where I did express concerns about cameras in the courtroom. When they were first being used, I expressed concerns about the jurors, were their faces going to be flashed? But I changed my mind over the years, and I'm on the record at my hearing saying that I support cameras in the courtroom. So that's not news. I answered the senator's question directly. I think it would really benefit society to see what we do. Of course, we would want safeguards for our jurors. We would not want their, faces flashed from one end of the trial to the other. But you don't have an argument with me on that. But, right now in the federal system, if I were to contemplate it, I would have to really start planning in advance. And I would probably I'm just estimating that I would put in a request and that request would be denied. That's
Is
what I'm
it-
thinking.
I don't know the answer to this question. I'm not sure that others do, but you more likely would. Is it something written down now in the federal system as a flat out bar for which you have no discretion ever to override, to bring in a camera?
I think, you know what, since I've been judge, I've been advised in, written papers that I've received that cameras are not used in the courtroom. Could a district judge try to buck that and attempt to get permission? Probably, but I'm not optimistic that that would be granted.
You get, yeah. It's flat out bar. Right. Right. Interesting. Who's going to, let's say she makes a ruling allowing it, who's going to appeal it if the defendant wants it and the US attorney is indifferent? Oh, he's opposing it. Oh, my. Yeah, sure. What if Smith and Company were in favor of it or were neutral? Who would appeal it? How would it ever get to somebody who can shoot it down?
Well, that's a good question. I mean, I think it's unlikely the judge will go this way, although I think if you go back and look at the policy considerations that were identified in Richmond newspapers in 1980, which was the first case in which the US Supreme Court identified a constitutional right of press and public access to trial proceedings, all of them apply wholesale in favor of recognizing a right of live audio visual coverage. And here in particular, given the unique singular national importance of this prosecution, I think it would be of tremendous educational value to the public to be able to see what is going to take place in this courtroom rather than to have to rely on secondhand mediated accounts and spin doctors giving their takes. So my view really is there is a First Amendment right to audio-visual coverage of proceedings in both state and federal courts. That is a minority view, of course.
Thank you.
There is, of course, in this internet-abled age, another route, not an alternative necessarily, but something that I think ought to happen, no matter how that motion is resolved, which is transcripts should be available for free and full ones. We live in an internet, sort of equipped era. And I think that at least, not everything has to come in 5-minute news stories. If people want to do deep dives, they ought to be able to. And it bothers me a great deal that very often for matters of significant importance that get carried out in trial courts, the real obstacle is the price per page.
All right, continuing in the scenario, we're getting to a couple of important issues that we want to be sure we have enough time to talk about. In the scenario, as this trial gets ready to go forward, jury selection gets underway and the prosecution moves, the government moves to close this to the press and the public, seal the questionnaires that prospective jurors fill out, which seek to get at any potential conflicts of interest or biases. And 3, impanel an anonymous jury so that even at the conclusion of the trial, we don't know the names of who was on the jury. The argument, of course, is that, let's leave the argument actually to the lawyers. Let's say that we have the prosecutors moving for closing this down, both voir dire and for an anonymous jury, and we'll have attorneys for the defendant and for the media in opposition. So let me hear first from the prosecution. You want to close the courtroom?
I actually don't, but let's assume for the moment I did. There is I should note, by the way, and I think the professor mentioned this before, for virtually any sensitive media issue, there is an office within the Department of Justice and Main Justice that would make these types of decisions for you, whether you could get a subpoena cleared to go after a reporter in certain circumstances, and whether you can get a court closure is one of those things that would have to be run through DC, including for something like Vardir.
How far up, by the way, do you think that kind of a decision goes?
I think that it is something that would, as a technical matter, probably be signed by the Deputy Attorney General. As a practical matter, there are too many things daily that need to be signed by the Deputy Attorney General, so as to suggest that he or she poured over, each and every one of them. Someone lower than that is probably doing the bulk of the work, but it's their signature.
Thank you.
So there's a specific framework with anonymous juries, but it typically has to do with the possibility of physical harm more than harassment. And when we're talking about harm, we're usually talking about like some concrete sense, for example, in 80s old style organized crime cases, that a juror's life may actually be in danger. I doubt that even anything like this in the aftermath of the events outlined in page 2 would necessarily arise to that level. And of course, if you do get this wrong, and the trial is still pronounced constitutionally infirm, it would be a heck of a reason for a reversal. So this is the sort of thing that I actually would probably avoid, if possible.
How about our District Attorney Flynn? Are you,
Ditto.
yeah.
I agree. Yeah, no, I would avoid this. Obviously, I don't have anyone to answer to above me. I can decide it myself. I don't have any chain of command. I am the chain of command. I agree with my colleague here. I would not do this. There has to be some, really valid reason for this, as far as, protecting, the life of a juror.
Well, what about being able to get juries in the future? If these jurors are scared to death, they see the threats on social media. They see, in fact, of course, witnesses are intimidated by Tusk in this case. And isn't there a sense that you would have a hell of a time getting juries in the future if people know that their names are going to be out there? And potentially then their addresses posted on social media?
Yes, I agree with that. There's a problem with that. I would let it play out a little bit though, perhaps, and see if in fact that did arise in the future, and then address it then. But I let it play out, and I wouldn't jump to that conclusion right away.
So you wouldn't close Vardir, but the names of the. Let me just ask the reporters here. Is there a reason that you want to know the names of the jurors in a case like this, other than what is the reason? Is there a reason?
Mostly so you can get them later.
We'll interview you. Oh, but doesn't the jury speak through its verdict? Why do you want to interview them?
Because you want to know how the decision was made, who the holdouts were, why they held out. You want detail on a case of this public interest and detail. I want to hear from as many jurors who will speak.
The Code of Ethics of the Society of Professional Journalists, Part 4 says minimize harm. Consistent with your truth-telling responsibilities, your job is also to minimize the harm that might come to as a result of truth-telling. So aren't you actually putting people in the line of harm if you're publicizing their names of these jurors?
In talking to them, you would ask, or they would tell you, I don't want you to use my name, and you would say why, and then you could judge. So it is possible. But you make a presumption that speaking to a reporter puts you in harm. I'm not so sure that's true.
Also, you want to give the reporters the opportunity to question the jurors, and then the newspaper, hopefully will be responsible enough to, decide whether that puts them in harm by publishing their names or not. There's also, with social media and everything else, there's a lot of ways the names get out anyway. So besides the journalists interviewing them,
For example, Facebook, they talk about it on Facebook and you go and find it there.
And as defense counsel, do you have an interest in whether voir dire is open, whether your jury is anonymous, or do you want your client to know who the jurors are and everybody else?
So I think the question, what we often refer to in court as open voir dire, is the opportunity for both counsel to be able to engage with the jurors in a meaningful way, to learn and figure out where they're coming from, what their biases are, and all of their, potential problems for sitting on this case. That process is oftentimes done without, behind closed doors. And that is a process that I think ensures the ability for counsel, both prosecution and defense, to be able to engage closely on some of these questions. So I think from a defense counsel perspective, the first part of the hypothetical where you're talking about the government moving to close the voir dire to the press, that is certainly something that I think both parties tend to agree on in these situations. But as far as, the anonymous jury, I mean, counsel themselves they will get the full names of the jurors. And it is important for counsel and the parties involved to know who the potential jurors are. But, at the end of the case, when the verdict has been returned and the court is releasing the jury, it is certainly, the jurors themselves are advised and cautioned and given the ability to do typically what they feel they're comfortable with engaging with counsel and the media. And it's really up to them whether they want to engage and talk to the media, whether they want to talk to the prosecutors, whether they want to talk to defense counsel and share their experience. And I think that is something that is always should be left to the jurors themselves.
We'll come to that in just a second. By the way, it's time for me to just say to the CLE applicants and to the journalism students, the code word number 2 is integrity. Code word number 2 is integrity, and I can now turn off the timer in my pocket. Thank you. Stop. And come back to this issue of the notion though that the public in this case, that the followers bombarding the jurors on social media could be in effect a 13th juror. You could have an awful lot of in effect, pushing jurors on social media by pressuring them to acquit. If you're, and this is before there is anything going on in the court that might affect the actual outcome of the case. There's a push by these people to intimidate the jurors. So this is not something that prosecutors can do anything about, because of the principle of wishing to have this information in the open, you're saying. This is, you need to have this anyway.
I will note, I assumed a voir dire process conducted by the court, which is typically my experience in federal court, where, it's part of the actual on the record proceedings. Of course, it's the case often that you've got, particularly I think in certainly last time I was a civil juror, you've got like a closed off the record proceeding, and it's fine to proceed with that if that's the way your forum goes.
We're almost ready to.
As far as intimidation goes, though, I mean, the principal recourse that we have is the ability to prosecute individual instances of intimidation. If there is some sort of an effort or plot to obstruct justice by intimidating witnesses or jurors, as Apple would have said some time ago, there's an app for that. There's a crime for that. And your principal recourse is to actually investigate those offenses and prosecute them when they rise to the level of something that can be prosecuted. There you'll find nary a system that doesn't have that kind of criminal violation built in And the action, I think my colleague here had said to sort of wait to see how it develops. That's why, because there may be something prosecutable there. And that too is an effective way of letting jurors know that they can't be intimidated.
Well, we come now to the fascinating culmination of this event, and that is an application by the press that the jurors in the case be instructed that they don't have to talk to the press, but that they're free to talk to the press if they want to. They asked that of the judge, and the judge said, I'm sorry, I'm not granting that. I'm not going to tell the jurors that they're free to talk to the press. As a matter of fact, I'm going to tell them that they may not talk to the press even if they want to. So how would that stand with the folks here? I'm not sure that, obviously the press would resent that. So we know that, and it's clear, and we know exactly, and we could speak in your shoes. So this is just the worst thing imaginable, because you want to inquire into what happened in the jury room, if bad stuff went on in the jury room. But let me ask the DA, where do you stand on the prosecutors? Where do you stand on inquiries of jurors after the case is over and there's a guilty verdict?
Well, to me, it doesn't matter guilty or not guilty. Personally, I've always, I've never seen this scenario right here in my life. Every judge that state judge that I've encountered always says to the jury, it's up to you. And so I would be against this in all regards. I'm not sure this is even legal, quite frankly, but you guys may know better than me. To me, this is illegal on the face of it, but I'm not a scholar in that regard.
Well, let me ask the judge, are there ever any circumstances in which you would ever, under any conceivable hypothetical pattern, tell the jurors that they're not allowed to talk to the press?
I cannot conceive of a scenario where I would do that. It seems to be a violation of their free speech rights, number one. Like many other judges, I will say to jurors, the attorneys, I usually say attorneys. I don't usually include the press in there, but I just say the attorneys may want to speak to you. If you would like to speak to them, you may. Most of my jurors run out of the courthouse as soon as they render their verdict. They don't seem to want to talk to anyone, especially in the criminal cases. And I wasn't asked, but I want to say that jurors, just to go back for a minute, many jurors do feel very uncomfortable about being on criminal jury panels, to the point where I've received letters. Why did you let that lawyer call me Mrs. Smith? I wanted to be called just juror number 3. Why are my names being used in front of that defendant? 3 days into a criminal trial, a juror asked to speak to me, and she came in and asked me if the defendant and his lawyer knew her address. I, thank goodness, had an alternate. I brought the lawyers in. I told them she was clearly fearing for her safety if she rendered a guilty verdict. So we excused her. We had an alternate. So I just want to say that jurors, it's rare to have an anonymous jury, but please know that everyday jurors in criminal cases are thinking about their safety. But as far as telling jurors that they could never speak to the press or for a 5-year period, I just think that, has that happened? Is that why?
Yes, it has happened. Mike, can you tell us about that? It's not a coincidence that this particular feature is there, because there have been judges who have put in a prohibition, jurors speaking out. Question, Mike, is it a contempt if the juror is violated? And how do you enforce it?
Yeah, well, enforceability is a really difficult question, Judge Rosenblatt, but folks may not be aware, but in the prosecution of Derek Chauvin, who of course was convicted for the murder of George Floyd in Minneapolis, the judge imposed a 6-month ban on the ability of jurors to speak with the press, even if they were willing to. And it was motivated out of a concern to preserve tranquility in what was a racially driven community at the time. I have serious questions about the constitutional propriety of that order, compounding what I think is arguably an error in the criminal prosecution of the two accomplices of Chauvin, which was in federal court for reasons I'm not entirely clear of. The judge imposed a 10-year ban on the ability of the press to speak with jurors in that case. So those two cases are now on the books. I think it does a real disservice because one of the very valuable things I find about press coverage when they involve juror interviews is invariably they show that jurors take their duties very seriously and they explain their reasoning, what the evidence was that led them to a verdict in a certain case. And usually the end result is to promote the perception of fairness about the operation of the criminal justice system and to legitimize the verdict that the jury reaches. This area of the law is changing more broadly. It used to be the case that there was a presumption under the First Amendment of press and public access to voir dire, to the identities of jurors, and again, to be able to speak with jurors post-verdict. I see a considerable retrenchment in this area of the law in the last 3 to 4 to 5 years, where that presumption has almost been reversed, particularly in high-profile cases, because the concern is among trial judges, and I think this is legitimate, and I think it's real, that social media is a game changer. And in high-profile cases where you have a defendant who has supporters, and it's a polarized case in a given community, the fear is on the part of the judiciary that the followers of a defendant or a party are going to, if the jurors are known, exert pressure, dox them, threaten them in a way that is going to cause them to reach a verdict perhaps that they might not otherwise have reached. And that is a real threat and a potential compromise to the legitimacy of the justice system. And we're seeing that all the time.
You say it happened in 2 cases?
At least 2, well, there have been anonymous juries entered with considerable frequency in the past 3 or 4 years. The state court prosecution of Trump in the Georgia interference with the elections, that is an anonymous jury. Just yesterday, another state court judge in Georgia entered an order in a criminal case involving some rapper who I was not familiar with, but apparently there are real concerns about how social media could potentially influence jury members there. The judge impaneled an impartial jury. And the point that's worth mentioning though too is there have been cases where jurors have been impaneled and they're not neutral. They concealed certain things that resulted when they became disclosed and known to the public after the fact that ended up resulting in their disqualification or even requiring a new trial. So there is value in exposing who's sitting on juries, and the press has often played a very important role in digging into the background of jurors and making that information known, because that too can be a threat to the legitimacy of the operation of a trial.
Well, my question is about with jurors, whether they're anonymous or not, are instructed by the judge, you may not speak to the press. Are those, does that happen?
Just in the two
George Floyd.
in the two cases that I mentioned, and I'm not
State-
sure if the order was jurors you can't speak or press you can't contact the jurors. There may be some differences depending on how the order is framed, but in the 2 Minnesota prosecutions arising from the murder of George Floyd, there were significant restrictions imposed on the ability of the press to speak with jurors in a way that, in my judgment, virtually destroyed the news value of whatever interview eventually does take
Are
place.
these both state prosecutions?
One state, one federal.
Aren't, they're both appealable orders. I don't know if the Supreme Court of Minnesota, I would imagine the press would be going up the line to the Supreme Court of Minnesota and to the, was it the Eighth Circuit or? 10th Circuit?
My understanding is that the press coalition involved in covering both of those cases made the judgment that given the unique circumstances of those prosecutions, as well as the nature of the political and social environment, that there was not an appeal taken from either of those orders.
All right.
Could I
Oh.
just say one thing? I mean, in order as a judge to have a unanimous, anonymous jury, you really have to specifically set forth the reasons why with great particularity. I mean, one of the issues from a judge's perspective is that the impact that it has on the defendant. If you have an anonymous jury, does that get that jury believing before the trial starts that presumption of innocence isn't there? Like, oh my God, we're an anonymous jury. And so that if I were to do that, and I have not done that, I would be questioning the jurors very carefully. You know, do you understand that the fact that you've been impaneled as an anonymous jury can in no way affect this defendant's presumption of innocence? Because after all, it's different, and you worry about that. Like, oh my God, we're anonymous. This guy must be guilty, or this gal must be guilty. So it requires a lot before you do it.
I think that's a great point, Judge Garcia. You could send a message to jurors that this is case and the dynamic that goes into it, that the influence of the race
See about the folks in the audience.
Yes,
5
if
minutes.
we have about 5 minutes. If there are questions from folks in the audience, or actually, if those of you online, we may be able to take some. Let's just see if there's anything we can get to here at the very end.
I will bring the
Okay, up
microphone
the
to you.
top.
anyone should be told.
Anyone in control? Oh, neutral. Oh,
Yes, is it really possible to have a juror who is truly neutral?
It's very difficult. I was a trial lawyer for 30 years. I would be representing a doctor, and a juror would say, well, I hold a doctor responsible for my mother's death. Okay, thanks for sharing. Do you think that you can be objective and impartial in this case that has nothing to do with your mother? Oh, yes, I can. And it's just like, just the way they said it. But I will say that most jurors in my lifetime of trying cases and presiding, they do want to do the right thing, and I have no doubt about it. They really do want to do the right thing, whether or not they can suppress the prejudices that they might have or the everyday life experiences. That's another thing. But if you're a good trial lawyer and you're a good judge, you really can talk to them about the Constitution so that they can hear the Star-Spangled Banner in the background and, you know, the presumption of innocence. I do believe most jurors come to the table wanting to do the right thing.
and the
I've seen
power
it.
of 12, I think, really helps. You know, we often get this question about journalists. You bring your own biases to your reporting. Of course, we all have human biases, but there are procedures in place and there are standards expected that help to assure that reporting is fair at legitimate news organizations. And I think the same thing occurs when you get inside that jury room and when you have the instruction that from the judge that with 12 individuals, that helps to ensure that fairness eventually becomes the standard.
Do you have any idea, Judge, how difficult this was? And I will say, I think I do. I'm telling you, they are like wet dish rags on the criminal cases when I go in to talk to them and to thank them.
I think we have completed. Thank you.
Speaking of thank yous, I want to thank our moderators, all of our fabulous panelists, and all of you for coming. And for a little bit of a reward, we have goodies downstairs in the East Foyer. I know we originally said the cafeteria, but it's going to be in the East Foyer on the first floor where you came into the building, most likely. So we hope you'll join us and we